The High Court of Trinidad and Tobago has ruled that anal intercourse between two consenting adults is no longer a crime. However, the offence of buggery remains on the law books of Trinidad and Tobago. Justice Devindra Rampersad's ruling modifies Sections 13 and 16 of the Sexual Offences Act in the landmark case brought by gay rights activist Jason Jones. Cozier-Phillip reports.
In his decision, Justice Devindra Rampersad said the court was of the respectful view that the most non-intrusive manner in which to resolve the issue of criminalizing consensual same-sex relations would be to modify Sections 13 and 16 of the Sexual Offences Act. Section 13 inserts the word "without consent" and will now be read as Section 13(1), a person who commits the offence of buggery is liable on conviction to imprisonment for 25 years. In this section, buggery means anal sex without consent by a male person with a male person or by a male person with a female person. Section 16 deletes the words "a male person" and "a female person" and is replaced by "persons." Section 16(1) now reads, "A person who commits an act of serious indecency on or towards another is liable on conviction to imprisonment for 5 years. Subsection 1 does not apply to an act of serious indecency committed in private between a husband and his wife, persons each of whom is 16 years of age or more, both of whom consent to the commission of the act. In essence, Justice Rampersad's ruling makes the offence of buggery gender neutral. Justice Rampersad said the result is therefore that there is no differentiation or unequal treatment afforded to consenting male persons. He said consenting female persons also qualify for the exemption. Justice Rampersad also said the court is satisfied that it cannot be accused of legitimizing the act, but rather striking out that which Parliament cannot lawfully do, having failed in establishing the legitimacy of the exclusion. Cozier-Phillip, TTT News.
The state intends to appeal the ruling of Justice Devindra Rampersad. Attorney General of Trinidad and Tobago, Faris Al-Rawi, says they will take the matter to the Privy Council for a final determination.
You must remember that the government takes no position in relation to this matter other than to clarify the law. The Supreme Court of Judicature in Trinidad and Tobago is the High Court and Court of Appeal. So we must pass through the Court of Appeal. Under Section 109 of the Constitution, the Privy Council is the highest court of appeal for Trinidad and Tobago, and ultimately this matter will go to the Privy Council.